Or good evening, everyone, and welcome to a new term, new semester here. And we are back here on Justice and Pieces. Really excited to be bringing this again back to you. First of all, to kick off the new term, we have Daniela joining us. Thank you very much for taking the time, Daniela, and chatting with us. Perhaps you can start by telling us, I know you wear a number of different hats, a little bit more about yourself, and so my students could know you a little bit better.
Great, absolutely. So thank you for having me. Pleasure to be speaking with your group today. So at the current time, I do have a number of hats. Main focus of my practice is mediation and alternative dispute resolution. I've recently expanded that practice to Ontario, Alberta, and British Columbia, which has been really exciting. At the same time, I also run a litigation and regulatory law firm. And I have a number of provincial appointments to tribunals and agencies as well. So at any given time, any given day, I'm sort of switching hats. I'm really enjoying all my roles, and it's a very exciting way to sort of craft your own unique journey in the practice of law.
Now, about that, I mean, I think that's interesting because every day is going to be a unique experience. But what can you tell me in terms of how you kind of compartmentalize, and how did adding in different provinces also come into play there on the mediation side? But how do you manage with the different things that you're doing?
So any lawyer probably experience a very or paralegal experience, excuse me, a very similar journey in terms of having different interests, and so managing those interests sort of manifests into managing different roles and positions. And so, in terms of compartmentalizing, that is where I say I start. And so, I actually am lucky enough to have a lot of flexibility in my hours. So, I actually compartmentalize my day into sort of boxes, so to speak, where a section of my day is dedicated to tribunal work, a different section of the day is dedicated to mediation work, litigation work, and then on a sort of high level, monthly basis, I deal with. I also take on roles as a hearings officer for a provincial agency. So then you have roles that are less frequent and that require attendances, let's say once a month or twice a month. That may also involve, sitting on a complaints and discipline committee pertaining to code of ethic issues. And so those are less frequent. So I sort of take a two-tiered approach to managing my schedule. One is on a day-to-day basis. And like I said, I divide that into sort of AM and PM slots, and where necessary, evening preparation. And the monthly sort of high-level stuff gets slotted in a little more, with a little bit more flexibility and ease.
And okay, so let's talk about mediation since that's your main practice area there. Maybe just give us a broad overview of what the mediation process is like and what that experience, I guess. Maybe let's start from being a mediator and what it's like sitting in and mediating disputes.
Great question. And I think that's an interesting start point. So mediation is it really is my passion project in terms of how I spend my day. And it actually permeates all of my roles in all capacities. Being a good litigator or an effective litigator, I should say, heavily involves being able to communicate clearly with parties, adversaries, and being able to also collaborate. And so I find that when I'm wearing the mediation hat, the parties who are most successful in mediation outcomes have that collaborative outlook and are able to properly assess strengths and weaknesses of evidence, for example, properly assess exposure, advise clients on what that looks like, advise clients on what those next steps are. And so as a mediator, it's also part of my role as I see it, not to just simply be a facilitator of discussions, but also take an evaluative approach. And so having litigated myself, I've also been a prosecutor in the past. I sort of invite those perspectives in and share my evaluative perspectives with parties in caucus sessions, which are essentially confidential one-on-one sessions. So I wouldn't sort of highlight the strengths and weaknesses of each party's respective cases in front of a joint session and their clients, but rather in a sort of private, secure fashion so that the parties have me to sort of assist in highlighting that.
So yeah, it's about caucusing. There may be, I guess, for some of the students who have no understanding, how how an actual mediation, like when they come before you, sort of the steps in the process before hopefully reaching some kind of resolution.
Sure, absolutely. So let's start maybe high level. Mediation is essentially the facilitation of negotiation where a third neutral party, such as a mediator, steps in and helps the parties negotiate effectively. So the beginning or start point of the mediation process begins right from canvassing dates with the mediator. You select a mediator who confirms that conflict checks are cleared. They can act as a neutral, meaning they haven't represented one or both parties in the past in their professional capacity. And then the next step is to exchange mediation briefs. So that step's a bit more nuanced if the matter is simplified procedure and subject to mandatory mediation rules. So mandatory mediation actions are governed by Rule 24.1 of the Rules of Civil Procedure. And in those matters extending to Ottawa, Toronto, Essex, it's mandatory for parties to participate in a mediation session within a certain time period. And that time period is usually 180 days from the close of pleadings. So under that stream, things are a bit more regimented. And so there's a few more forms to fill out after exchanging your mediation briefs. And that would be advising the mediation coordinator, for example, in Ontario, who you've selected to be your mediator, whether they're a roster mediator or not. Or in the alternative, if the parties cannot collaborate or agree upon who their mediator should be, the mediation coordinator has the powers and discretion to appoint a mediator off the mediation roster list. So there's sort of two ways of being assigned a mediator or selecting. So that's where the sort of starting point is. Now, if it's not simplified procedure, you can simply select your mediator with the other party. And perhaps a good approach I usually recommend is, propose your top 3 picks for who a mediator is that you believe would be well suited with expertise and experience for a particular subject matter. So once that's done, you'll exchange your briefs. Briefs are highlighting your positions, your interests. They should not be cut and paste of your pleadings because the plaintiff will have the onus to enclose or affix as an appendix all the pleadings in the action to their mediation brief. So it's not a sort of cut and paste exercise. You're really distilling down for the mediator what the main issues are, what the grounds are that you are relying on. And so that could be legislative grounds, any authority you're relying on, case law. You'll highlight the evidence you believe is your strongest evidence, for example, and what you seek to achieve ultimately. And a great mediation brief also highlights for a mediator what a settlement looks like. So there's different types of agreements. If you feel that one is more suited to your matter, then include that. The more information, the better. And then when you start your mediation, a lot of these, as you know, are being held virtually. So, back in the in-person sort of format, we'd have essentially 3 rooms. One would be a joint session where we would start the mediation and start with an introduction. It would look like an opening statement where each party has an uninterrupted period of time of 5 or 10 minutes, but that's a flexible time frame depending on the complexity of the matter, to present their case and essentially, make their pitch. After that opening statement presented by each party, the matter usually breaks out into breakout rooms. And so we leave that joint session and one party occupies one room, the other party occupies the other room, and the mediator essentially shuffles back and forth. And that is called shuffle mediation. And so you meet with each party and you essentially, in a confidential, frank, and open atmosphere, discuss what you're looking to achieve off record. The mediator is bound by confidentiality provisions, subject to exception. So, for example, if there's some information pertaining to public safety, health safety, and so forth, these are rarely sort of encountered, but each party would be represented by their counsel who would advise them of that. But mediators do remind parties of that at the outset. So you have those sort of ground rules to work with. So that the mediator meets with each side, really delves into what their interests are, and after distilling that, assists the parties in communicating what they believe is an effective offer. So an offer where you're not giving too much, but you're giving enough to really demonstrate that you are meaningfully participating in good faith in mediation. And so that shuffling goes back and forth, moving offers, and ultimately, in the ideal situation, there would be a meeting of the minds, and the parties would agree on a number. Then we would join the joint session room once again, clarify the scope and nature of what the agreement is. A mediator can assist parties in developing or drafting settlement minutes, and reach a successful conclusion.
Now, you mentioned they're virtual versus in person. I don't know, from, let's say, in the mediation, as a mediator, is there a preference that you found over the last couple of years, now comparing that to being in person? I mean, besides maybe the location having maybe a nice spread there, are we missing out by going on Zoom or however?
I don't think you're missing out. That being said, I don't think there's a blanket rule or approach. I really think that it's a case by case basis. It depends on subject matter. There are cases where plaintiffs, appellants do not wish to, sit face to face with the defendant or the accused, and doing so may in fact frustrate the negotiations. So again, case by case basis, I usually conduct a pre-conference mediation call, or a pre-mediation call rather, where I canvass these issues with party. I get a good sense of what the relationship is. And so mediation really is about trust and relationship recovery, rebuilding. And so after getting a sense of what the sort of status quo is there, I propose what I believe the proper format is, also taking into account what the parties' resources are. Virtual mediation, it really has a lot of benefits in terms of cost saving, avoiding facility fees. But then again, there's other matters and subject areas where there's a high level of complexity. I deal with construction defect issues as well. And I may have drawings in front of me, blueprints. That kind of stuff is very difficult to sort of wrestle with over virtual, depending on the nature of the documents. And so you may in fact want a room where you physically have evidence that you can lay out and mark up and touch. So it really depends on the subject matter. I am finding an uptick in virtual mediations in the employment law subject matter. I'm finding it's working really well, that there's often a relationship, a strained relationship underpinning that subject matter between, for example, a wrongfully dismissed employee and an employer, and they do not wish to sit at a table. And that's fine. And we can accommodate that through virtual mediation in breakout sessions. We have a lot of flexibility with technology nowadays. And some people are just really comfortable sitting in their lawyer's office, or even sitting in their home. And they have the privacy they need. It increases accessibility, inclusiveness. So it can really work for you in certain matters, and in others, it may create some impediments.
Now, the other thing there with the different roles that you have is, how do you find that having the litigation experience helping you as a mediator, and then having the mediation experience helping you as a litigator going through the ADR processes?
It really helps. I think that being an effective mediator, so I've been practicing law for over 10 years now, and having that litigation experience having even the prosecutorial experience, adjudicative experience, it really helps. Touching all corners of dispute resolution just amplifies and really helps you bring a skill set to the table when you're wrestling with subject matter, especially. So, dealing, for example, with the Employment Standards Act, I've litigated using that legislation. I'm conversant and sort of know how to navigate and pivot between rules and sections, familiar with case law. So that sort of foundational baseline knowledge really helps a mediator in engaging with the parties, especially using an evaluative approach when you're asking the parties, have you considered this? Or have you, come across this case? Have you considered that case? How it applies to yours? Is it distinguished? And so forth. So I think it really helps. And then on the litigation side, when I'm selecting a mediator for my clients, there's a certain type and focus that I'm looking for. I'm looking for someone who focuses on relationship building, for example, depending on the dispute. For some business disputes, commercial disputes, repairing a business relationship is actually more important to the parties than the actual quantum of a breach of contract, for example, that's in dispute in the pleadings. So you really want to find a mediator who can offer that level of assistance and help broker a deal that not only meets just a number or a value figure, but also repairs relationships and focuses on trust building and communication.
You mentioned they're facilitative versus evaluative. In terms of maybe in your experience as a mediator, have you found, you've mentioned maybe more on the evaluative front, but is it sometimes where they just need people using sort of those soft skills, bringing them to the table more so than the subject matter expert kind of explaining, well, here's what may happen if it goes to trial or to a hearing?
Absolutely. So this sort of brings to mind something that is sort of well known at the Harvard Law School. Professor Robert Nukin. He distinguishes between a tension that he calls creating value and expanding the pie, so to speak. And so this idea of distribution or zero sum win lose is a really antiquated way of looking at disputes. And so what I mean by that is if you've ever come across the sort of anecdote where there's two sisters fighting over one orange, you're nodding your head, so I think you're well familiar with that. But it's a really good analogy for the question you asked. So you have two sisters squabbling over one orange, and neither of them sort of stops to think, why do I want this orange, and why does the other sister want this orange? Rather, after straining the relationship, creating animosity, emotional blowups, and all that, they decide, let's just cut it in half and call it a day. That's an example of distributive bargaining. It's sort of a cut in the middle. Neither party's really winning. And so when they go off and they use their orange or their respective halves, the one sister says, well, this is not satisfying. I just wanted to eat the orange and I'm still, wanting to, eat the other half. And the other sister peels that orange, throws the inside away, and uses the peel to flavor a dessert, and was just interested in the orange zest. And so had they sat and really discussed their needs, they would have actually ended up with more of what they each wanted through a win-win situation. And so this example reveals the sort of importance of focusing on parties' interests and the importance of being forthcoming with your interests. Now, neither of those aspects or skills require subject matter expertise. It's an inquiry. It's an inquisitive inquiry. It's sort of driven by your observations of how people communicate and really delving in to figure out what would make them happy. And so to answer your question, I do not believe subject matter expertise is always necessary. You don't need to know the ins and outs of legislation. There's exceptions if we're dealing with tax law disputes. I think that might be a subject area where it might be a bit more nuanced, and it would, I think, help. But lots of civil litigation areas are very conducive to relationship focused bargaining. and looking at really what people's interests are, and a mediator having creative solutions to expand the pie, so to speak, and create value there.
No, and I always love that analogy. We were just talking about that yesterday. That's why I was nodding there about the oranges. But on that point, how, in terms of where you're looking at getting the parties to focus, and you mentioned, well, you don't know if they don't talk about their interests, right? Like, let's say it's a dispute between, the employer and the employee, but maybe they're not talking about the fact that working from home is really what we're looking for, and how can the other party know if that's not brought to the table? So what are some techniques maybe in getting more of that shared in the mediation sessions? Now, you mentioned obviously the caucusing and going back between the rooms, but what do you do to kind of get people out and talking?
Sure. So it all happens in caucus sessions for me. Parties who and lawyers who have mediated with me will often remember me sort of going through just a sort of casual, informal discussion of tell me about this. It really is an inquiry. It's a lot of open-ended questions and really listening to understand, not listening to respond. And then once you feel like you have a good handle on things, sort of reiterating, rephrasing, restating what you understand to be the interest or concern of the party, and then perhaps highlighting the benefits of sharing that perspective and why it would be beneficial. And so I've come across examples of that many times where, it's not until a caucus session that, a party says, well, that wouldn't suit me because I'm more interested in X, Y, and Z. And I think to myself, it would have been really great if that was highlighted in the mediation brief, because then the other party would actually know. So we have this sort of tension, a further tension between hard bargaining tactics and naive sort of bargaining. And I'll just sort of go through that. You'll see hard bargaining tactics to look something like holding information back or holding your cards tight, thinking that not making concessions or not unveiling or revealing your true interest in the matter is a good thing, because if the other party knows, they may manipulate information or offers to use that against you. Now, not revealing too much really is a double-ended sword. It's really not helpful. At the very least, I would suggest that parties reveal what they're looking to achieve to the mediator in a confidential session. It's always great to have a sounding board. A trusted mediator will sort of highlight to you what they think the strengths would be in revealing or sharing that information, and why that is the case. The parties are always in the driver's seat. Their counsel and the parties always determine what information is ultimately shared. But just engaging in that collaborative effort really will help matters get moving. There's an aspect of reciprocity I always focus on. And you mentioned when we chatted that you had been sort of following some of my LinkedIn posts. And reciprocity is something I always highlight to parties. If you put out a hand of good faith, it is actually human nature for another party to duplicate or reciprocate that. More often than not, it will inspire a party to make a concession rather than turn someone away or close them off. And so we want to also take into account human nature and cognitive decision-making patterns and psychological sort of ways that people normally approach conflict, and really take that into account. So we have this hard bargaining, one end of the spectrum, and then we have this sort of what some people call naive bargaining, where people may show all their hands, or they may disclose too much or trade most of what's important to them from the outset. A trusted mediator will also draw a line in the sand and say, you know what, let's hold back on that offer. I know you're willing to offer this much, but I would suggest you make a lesser concession, and let's just hold that bargaining power for the next sort of trade or the next sort of exchange of offers. And so mediators can really help shape the sort of momentum between parties. And so this idea of reciprocity is really tied to momentum. Once you get things going, you want to flow with that. You want to just carry on the collaborativeness. You're building trust, you're building good faith with the other parties. Again, it's balancing that tension between hard bargaining and naive bargaining. And a mediator can really help navigate those waters.
Now,
And
what's
the communication between the parties, once they learn what the underlying interests are, and help them articulate that.
Now, what's always interesting with, in mediation and any ADR process, it's happening, you're talking about collaborative approaches, but meanwhile, if this goes to a trial, it's going to be adversarial. And you were talking about holding things back because, well, what if they know what you're going to be looking at trial and you've kind of put all the cards there on the table, and should this falter, or if maybe there's that fear, the other side's not really approaching mediation or mandatory mediation with an aim of resolution, then we've just kind of given away what we're going for, what we may be asking for and pushing for in a trial, and now we're gonna be in a worse position. Isn't it better to kind of hide things there in the hopes that we can bring that up at trial and be in a better position? So how do you kind of rectify that collaborative approach needed in mediation if this goes to trial, it's going to be adversarial?
That's a fantastic question. So what I always start with is evidence must be available for discovery in trial in civil proceedings. And as we know, we're sort of limiting the scope of this sort of discussion today to civil proceedings. So the parties have many duties. One is the preservation of evidence. So there's actually an interesting Court of Appeal case from Saskatchewan, and I'll just actually pull up a quote. I don't have this memorized. So it says, a party is under a duty to preserve what they know or reasonably should know is relevant to an action. The process of discovery of documents in a civil action is central to the conduct of a fair trial, and the destruction of relevant documents undermines the prospect of a fair trial. So that is a case from 2002, Douse versus Schatz. And this is the sort of foundational requisite knowledge and requirements to participate in a fair trial. So what does this essentially say? It says there's a duty for parties to preserve what they know, and there's also a duty in discovery to produce what is relevant to the proceeding. So we sort of segue into topics like the spoliation of evidence, for example. There is only so long you can hide or suppress important information. Parties are not permitted to hide or suppress information at that stage of the litigation. In fact, by the stage of exchanging affidavits of documents, the parties must disclose all information they're seeking to rely on at the trial. And even if they're not seeking to rely on it, they must disclose it. And this is, of course, subject to different things like privilege and so forth. I'm not going to get into the substantive sort of nuance of that, but I want to just focus for a sec on the spoliation of evidence matter. So courts have developed evidentiary and procedural rules to sanction litigants who damage, mutilate, alter, or conceal evidence. Spoliation can occur in different ways. Documents can be shredded, for example. Digital files can be erased or altered. Physical items can be destroyed or altered. Evidence can be suppressed. Now, those who suffer from an act of spoliation, they may be entitled to remedies. So, for example, the courts have evidentiary presumptions or procedural sanctions, etc. And so a potential argument can be made against the spoliator. So if the spoiled evidence would have been available at trial, a party can argue that it would have been harmful to the spoliator's case, whereby they're essentially inviting the court to make that presumption or adverse inference. So like I said, I don't want to get into the sort of substantive elements of what the duty is, but rather to remind parties that if mediation fails and the parties are on their way to participating in a trial, there are repercussions for not following these rules. And so if you're holding your cards tight at a mediation, eventually they will come out. They will come out. And, part of this, I think, is the reason a lot of matters, they settle right before trial, because by that time, evidence is collected, it's organized, it's sort of digested, analyzed. The parties are now conversant with one another and really getting into a dialogue as to who they're going to call, what that expert or witness is expected to say. And it's at that point where evidence is so readily available and the parties are so familiar with it that there's an opportunity, a sort of sweet spot, if you will, for concessions to be made and for meaningful discussions with respect to resolution to be had.
I wanted to switch gears a little bit because you were talking about posting on LinkedIn, and maybe we could start there with sort of where did that kind of come out and how you found, networking on the community there. And then we'll go into some of the recent tips that you posted on there. I think talking more on negotiation and mediation as well, aspects there. But maybe tell us a little bit about sort of how it kind of grew, or, you're sharing all of this information, valuable information on that platform.
Absolutely. So it really started after or when I started mediating in my own practice. So 2017, I believe, I completed that Harvard negotiation leadership program and got certification. And I think it was at that point I sort of had the seed planted where I had this interest in the academia or academic side of and sort of a knowledge of why people do what they do when they're litigating and when they're mediating. And so that really planted the seed. And it wasn't until 3 or 4 years after that that I actually rolled out my own mediation practice. At that point, we're still virtual and there is nothing in person, and networking is really difficult to really do when you're not, rubbing shoulders or elbows at an examination center or in court. A lot of things are virtual. So I thought through that program at Harvard, I had connected with a number of incredibly minded and intelligent mediators, internationally located. And so we developed networks through that platform, and it just sort of grew organically from there. I sort of put my mind towards a more regimented posting setup about 8 months ago. And I, said to myself, at the very least, I want to post once a week. And I'm really posting things that at least I hope add value, where someone can read it and say, wow, I never thought of it that way. That's a helpful tip. Or I had that, similar situation. And, next time maybe I can, think of this tip or whatnot. And so that's the sort of objective. Is it's a networking mechanism for me. I've had so many fantastic lawyers reach out to me, engage with my posts, and my platform has grown substantially. So when I had started, I think I've tripled my sort of audience or followers since then. So I have it's a very exciting thing. My network has grown so much, and I really do interact with all of or a lot of the lawyers and clients that follow me, and other ADR practitioners. And it's a really great information sharing platform. And it actually was the segue or impetus for me expanding my practice to Alberta and BC. Just having received inquiries from some lawyers out west and asking, hey, can you mediate this employment law file for me? I'm in BC, and I went through the appropriate channels to clear all that, and off I am to roll out in 3 wonderful provinces, hoping to roll out in more as the need arises.
So I mean, we'll look at some of the tips there. Some of my students were going to do like a little negotiation role play, and in school it's always these very nuanced, sort of complex issues there to kind of get through. And then you sort of shared some advice of how to navigate when there's all these issues in going into a negotiation and potentially into a mediation. So you can share us some tips there for those students as they get ready for doing their first kind of ADR role play.
Absolutely. I would say the first tip is on you can never be over prepared. So preparedness is step one. Now I know that you're teaching a class on evidence and litigation in civil litigation, and so the collection or exercise of looking at evidence really starts from the outset of a matter, from client intake, really. Collecting evidence, organizing evidence, interpreting it, advising clients on the onus they have to preserve their evidence, both physical and electronic, and so forth. So in terms of recommendation or a tip, it would really be on entering or starting the matter on the right foot, and using that due diligence, whether it be coming up with certain checklists. I remember I've litigated at some wonderful law firms in the GTA, and all of them had some sort of regimen in terms of a checklist that guides you through what intake looks like, what the law society requirements are when dealing with clients, identification, privacy concerns, conflict checks, and so forth. So I would say that all falls into the bucket, if you will, of preparedness. The next sort of tip in negotiation is relationship building. Reach out to opposing paralegal or opposing counsel. It really is important to arrive at the mediation table having some acquaintance with the other side. Just looking at pleadings or exchanging written email correspondence is not a sufficient level of relationship building, at least not to the extent you need to really develop a good collaboration at a mediation. So pick up the phone and call. I think it sends a message that you're eager and willing to approach a matter in a reasonable way. And I think it's really helpful. Another sort of aspect or tip would be getting to know your client. So I've already alluded to collecting and organizing evidence. Really collaborate with your client. It will help you assess the causes of action and damages that arise. You're getting that firsthand experience from the get-go. You can explain the litigation process. You can reflect what you need to reflect in your retainer. And so you want to be a hands-on advocate. That would be another tip, I would say. And then a further tip deals with pleadings. We want, concise, chronological, clearly worded pleadings. No need for legalese. There's no need for words to be in sentences that don't add value to sentences. So, there's lots of sort of online courses or tips on how to be a concise writer. And so I also encourage parties to use chronologies, if not in pleadings, even in a mediation brief. I think it's really helpful. And it also points out where the facts differ, where there's, a disjuncture in understanding or perspectives. I also want to highlight for the parties that you don't ultimately have to agree on the facts in order to reach a resolution. You also do not need to agree with a party's perspective in order to demonstrate that you understand what they're saying and you understand their perspective. I think those aspects are really important and really contribute to success in mediation. So, even if you don't agree with what happened, there is still room. There's still a window of possible agreement. So sometimes a mediator may say, let's put a pin on that. Let's agree to disagree, or at least agree to put that disagreement aside, and let's work with what we can perceive to be mutual exposure, mutual risk, and a sort of cost benefit moving forward. So I think that's another really important point in terms of helpfulness. And I'd also emphasize the fact that parties in a mediation, it really helps to respect not only your autonomy, but the party's autonomy as well. And so this all goes towards trust building, avoiding hard bargaining tactics. Everyone it is important for everyone in a matter to feel that they have an appropriate degree of autonomy. This may look like, taking an indulgence, agreeing to a break, allowing a party to call a stakeholder that, has the discretion or authority to, authorize a settlement amount. So that type of conduct really helps. Good conduct really creates a platform for parties to reciprocate with the giving, and if it's just taking, it's just going to sort of spoil the momentum. So those small gestures really go a long way. And I always encourage parties to have a good sense of, what the dynamic is between the principals and the agents, between, lawyers and their clients, between, for example, a labor leader and on behalf, that's acting on behalf of a union. Sort of forecast, get a feel for what that dynamic is, because as a representative, you may or may not want to have certain discussions with the other lawyer in front of their client. And so that may put external pressure or frustrate negotiations unnecessarily. And so you also see in a mediation, a mediator may in fact just meet with counsel in a separate breakout room. So just the mediator or the paralegals or counsel or representative, and have a frank discussion without the clients there. That always offers a certain breakthrough where things are really tough, where there's a lot of animosity. And I find that, these little windows of potential breakthroughs, they exist in format, they exist in substance, in procedure. You're always sort of adapting, and please always feel free. I mean, your clients, so feel free to recommend to the mediator, why don't we try this? Why don't we break out in this room? Let's flip this all around. Let's just bypass opening statements. They're unnecessary. It's going to just re-aggravate the parties. Then we'll have to de-escalate disputes, de-escalate high emotions. It's a collaborative exercise. So that's really important as well. My last tip is managing the tension between empathy and assertiveness. So empathy is not necessarily about being sensitive. It's more about understanding the conflict, or being able to understand the conflict from the other person's perspective. And so when doing so, as a representative, for example, I would explain to my client, have you thought of the perspective of the other party, from where they're sitting? And that doesn't mean that you need to forego or ignore or diminish your client's interests. You just want to highlight what the other side might be thinking. And that really helps in trying to determine what their interests are, right? If they're only looking for the peel of an orange, why are we brainstorming on how we're going to make orange juice, for example? So, and then on the assertiveness side, we want to be, clear, concise in what your needs and concerns are, and not overly aggressive, because that really is just going to create tension. So I think that's another thing to sort of evaluate during, and always sort of check yourself and check your feelings, and use the emotions to your advantage. Don't let the emotions use you. We want to leverage as much as we can in terms of benefits in a mediation and a negotiation.
Perfect. So Daniela, thank you so much for taking the time here and joining us. Perhaps if you have any final words of wisdom for the students that are listening. And once again, we appreciate you sharing your wisdom with us, and hope for any final parting words.
Thank you for having me. And I want to wish the students in the program a wonderful semester, a wonderful term. I know that this is such a fantastic program over at Seneca. And I'm just excited to welcome you eventually. I think it's a 2-year program, is it?
I guess it depends. There's like accelerated.
Oh, it depends. Well, I look forward to welcoming you into the community. You're already part of it, just being enrolled. And when you start to collaborate with other parties, it's really exciting. It's a wonderful profession. Each each lawyer and paralegal brings so much diversity and exceptional skills to what they do, and so the profession needs you, and I really welcome you, and you'll be part of some wonderful teams and bring so much forward. And the exciting thing too is you have so many options. I know we talked about all the hats I wear. You'll have those similar opportunities to craft what a position, or craft a career that suits you and what you really want. So congratulations on your start, and yeah, I wish you luck. And if anyone has questions and wants to reach out directly, please do. My website is www.danielacorapilaw.com. Reach out. I'm always happy to speak with people, and thank you for having me.
Perfect. So thanks everyone for tuning in. Thanks again, Daniela, and all the best, and getting started here on a brand new semester. Take care, everyone.
Thank you. Take care.